Okay, we're getting ready to get started.
Yep, let's get rolling.
Let's get her done.
Okay, folks.
Let's get her done. Woohoo! Come on, guys.
Okay. All right. Okay, folks, we ready to get going? All right. Now, I need to address a couple things, okay? As we've all seen on different TV shows and different things, this, and one gentleman shared with me, a lot of what I'm teaching is controversial. I don't know if it's controversial, but yes, it is controversial. So was the Declaration of Independence. That was very controversial to the king, to the crown. That was very controversial. The Magna Carta was very controversial to the king. But people did it anyway because it was the right thing to do. Now, in regards to the sovereign citizen, anyone claiming to be a sovereign citizen is trying to walk on two different jurisdictions. A citizen under the water, under the statutes, the 14th Amendment, and a sovereign under God's law. Now, I read to you earlier Supreme Court cases that says that people are sovereign and that code statutes and ordinances are not law. So saith the Supreme Court. So saith the Supreme Court that people are sovereign. Code statutes and ordinances are not law. They are contracts that people can engage in willingly or they may be sucked into unknowingly. All right? So, let's just take driving, for instance, because I had a conversation with a lady over here that says she was talking to a police officer about it, and he said, I arrest them state nationals all the time. Well, I don't know if he's arresting state nationals. He couldn't arrest a state national if you looked him up on his LexisNexis on his cruiser and saw their status. Because when you look it up on LexisNexis and see their status, if they've corrected their status properly, it says on LexisNexis, it says, and I quote, restricted. That means that the police officer, the judge, the prosecuting attorney, the sheriff is restricted from seeing any of your information beyond this. It says, do not detain, do not interrogate. It also says, notice, lifetime 50 state concealed carry. That's what LexisNexis says. That's the only information they can see, because if you've corrected your status correctly and you have your passport, LexisNexis is updated. So when they look it up, they see that they have no jurisdiction over you. You're not a U.S. citizen. If you've done the process incorrectly, your LexisNexis will not update. And when they look you up, they will arrest you for fraud and swindle, because you think that you're a state citizen or a state national when you're really not. There's a lot of groups out there, quite a few. There's two the ones that are most prolific is one called the American States Assembly, run by a lady by the name of Anna von Rice. I am convinced that she is pure evil. Okay? She does not do the process correctly. The people that follow her method do wind up getting arrested. They get their homes seized. They get their bank accounts seized when they walk around thinking they are a sovereign, when they are not. In order to become, what's that? Anna von Rice. And Rice is spelled the German way, not R-I-C-E. Yep. So I have quite a few people on the channel that have went through her process and gotten in trouble and discovered what she does and who she is. And they call me up and they say, "Oh my, please save me. You blocked me from your channel. I'm so sorry. I was pushing her. You were blocked from your channel so that other folks don't get sucked into that, because she says you can correct your status with one single page. That is not how you correct your status properly, with one single page. It takes about 25 pages to correct your status. Here is my Freedom Bundle, certified true copy. It says affidavit of truth and accessory oath, repudiation and revocation of citizenship, certified proof of service, notice of certified judgment of unrebutted affidavit, a deed of reconveyance of my birth certificate's legal fiction person, and a patent of nativity that proves that my bloodline DNA was on this land prior to there ever being a government or a corporation pretending to be government. And this went unrebutted. And this is my Freedom Bundle. It happens to be 37 pages long. When I did it back in March, if I had it to do it again, it would be 137 pages long, because I've learned so much more since then. Everything in here is a settled matter of fact before the court of the land juris. It went unrebutted in the form of an affidavit. It was sent to President Joseph Biden, and I got a certified default judgment against President Joseph Biden and the Secretary of State, Blinken, that I am a people. I am a state national. And their code, statutes, and ordinances and legal stuff made up do not apply. It is a settled matter of fact. This is how you properly correct your status. We'll teach you how to do this tomorrow, the parameters of it. All the details will take a week or two for you to learn through self-study. And even then you'll make some mistakes. That's why we have administrators on the Telegram channel that will review your documents for free to make sure you don't make any mistakes and wind up in jail. Okay? This is up here for anyone who wants to read it. That's how you properly do it. Is it controversial? Yes. I poke them with a stick right in the eyeball. Yep. So, let's deal with traffic cases, and do I need a driver's license or not? Because a cop, a police officer, who has been trained by a bar attorney does not have any clue what it is to be a constitutional sheriff or a constitutional law enforcement police agent. So this is the U.S. Supreme Court and other Supreme Courts of the states. These are citations proving that no license is necessary for the normal use of an automobile on the common roadways in any state of the Union. Those are the lower 48. Hawaii and Alaska are under the UN corporation, corporate United States. They are not de jure states. They are de facto United States. So, this is from the Supreme Court and other high courts in our land that says you do not need a driver's license. And I've got 4 pages of them. And the little police officer that thinks he's going to arrest you for not having your driver's license, if you own the allodial title, the superior title to your automobile, and you turn it back into an automobile from a motor vehicle, it is yours. If you're still driving a registered, state-tagged motor vehicle and you claim any of this, you will get locked up. It's only your private property when you make it your private property. You don't own anything. You have warranty deeds, a warrant that you don't own it, you're a tenant, and it's a warranty. T means you accept it. Warranty deed. It is not a grantor grantee deed, simply stated. And it does not have proper metes and bounds under our supreme law that deals with metes and bounds. What is that supreme law that deals with land? It is the what? Of the four? What's the fourth one? The Northwest Ordinance, or the Northwest Compact. It's listed as the organic laws, as one of the organic laws of our nation. It is the supreme law of our land. All state laws fall under that law. All federal code, statutes, ordinances, and act of Congress fall under that law because they are not law. So this is from the Supreme Court cases. The right of the citizen, even a citizen who hasn't corrected their status, to travel upon public highways and to transport their property thereon by horse-drawn carriage, wagon, or automobile. Doesn't say motor vehicle, does it? It says automobile. The judge is telling you automobile. Doesn't say motor vehicle. A motor vehicle is owned by the state because you turned it over to them and you got a certificate of title. It is not the title. So if you turned your motor vehicle back into an automobile, or if you bought a brand new one and you walked out of the dealership with your superior red ink certificate manufacturer of origin, you have an automobile. And it says, is not a mere privilege which may be permitted or prohibited at will, but a common right which he or she has under their right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee, one may therefore, under normal conditions, travel unmolested at his inclination along the public highways or public places, or in public places, and while conducting themselves in an orderly and decent manner, neither interfering with nor disturbing another's right. They will be protected, not only in their person, your vessel, but also in your safe conduct. You see that flag I showed you, the civil flag of peace that's folded up there? As a state national, you are to be at peace and do no harm. Do not trespass. Do no harm. When you violate that, when you do harm, when you trespass, when you run into somebody else's motor vehicle, you cease to have the protections and you get pulled into the water because you trespassed upon another people. It applies to an automobile accident. If you have your automobile, your superior titles, and you run into someone, you now have to make compensation for the damage that you caused. Okay? That is common law. That is God's law. We do what is right and righteous and just. Okay? The judge told you that just there. As long as you're not disturbing anyone, depriving them of their right to travel, and you are at peace, you have your right to travel without a driver's license. Thompson v. Smith, American jurisprudence. American jurisprudence is the guide rails for judges to follow. You must be prudent in your judgments, in your opines, and your opinions. You hear the way I'm talking? Words and how you pronounce them mean very much. The highest form of ecclesiastic law, the highest form, the form is how you convey it, is not writing. The form and how you convey the diction is how you say the words. The oral argument is the highest form of conveying the diction of law. How you speak accurately, succinctly, and with a cogent purpose is very important. In all of your interactions with actors pretending to be government employees, when they are not, they are mere corporation employees. And most of them don't even know that they work for a corporation. You'd be surprised at the number of elected employees. I go back and I pull up a little township that they work for under Dun and Bradstreet is incorporated, and I pull up their corporation number, their Dun and Bradstreet number, and then I pull up the officers, and they're listed as one of the corporation entities. They are listed as a corporation, an officer of that corporation. So the little town of Chambersburg, one of the town council members, was baffled that this was even true. So I sent him a screenshot of his name as the principal of the corporation under Dun and Bradstreet number blank, 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 blank. His name appeared. And he's like, oh, wow, I didn't agree to that. I said, sure you did. You signed some documents, didn't you? You put a signature on them, didn't you? Yeah. Did you read them? No. Maybe you should have. You're a corporation officer. You are not a public servant. And he had to sit down for a minute because this guy's a patriot. And he loves our President Trump. And he believes in the Word of God. He lives a good life. And he doesn't know that he had fraud perpetrated upon him. Most of them do not know. It's up to you to educate them. You see, we lose our liberties and we lose our freedoms because we do not know how to defend them. Most of us don't even know that they were stolen from us. And that's how we get into this predicament that we are right now. Okay, there's a couple things here I want to show you. On my Telegram channel, there is these documents. There's over 100 pages here that explains what a constitutional sheriff and law enforcement is, and it uses citation after 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 citation. Remember what a citation is. It is a settled matter of fact before a court. An administrative court or a constitutional at-law court. These are citations. They are for free, and they are posted on the Telegram channel under files. We have a common law handbook for jurists, sheriffs, and bailiffs. We have a the county sheriff's handbook, which educates that sheriff on what their proper role is. This one is 84 pages of nothing but truth and fact. It is the same for every state. Under the guarantee clause of our Constitution, the member states of the Union agree to pay respect to laws of other states. That's why your driver's license has reciprocity in all 50 states. Because the laws apply no matter where. Many of the cases in this handbook are Supreme Court cases for every venue. You see, judges and attorneys, judges and sheriffs and police officers think that the little town or the county that they're the police officer of or the county sheriff of, they think that's their jurisdiction. No, it's not. Your bar attorney only knows one jurisdiction, the water. That's why they use the word jurisdiction synonymously across all three jurists of law, because they intentionally or ignorantly, stupidly want to mislead you, or they have been misled and don't know the difference. It is a venue. And in that venue, there are three jurists of law. And the bar attorney only talks about one jurist This deals with all the jurisdictions in that venue and all the venues across the country. I could stand up here and read this thing to you, but let me just open to any page, any one page. Court duties, sheriffs and warrants, general rule, law of the land, the U.S. Constitution, there's a citation, law. That which is laid down or ordained or established is law. That is by the people is law. Koenig v. Flynn, Supreme Court case. Let me just find citations here. Blah, blah. The first part of this deals with ecclesiastic law. So its citations include Luke 7:30, Luke 11:46, Luke 11:52. The Constitution, Isaiah, Exodus, Job. That's the citations in the ecclesiastical part of it. Because remember, canon law is the highest form. Ecclesiastic law for those of sovereigns. And then the further back you go, it gets into the different. Like this is the law of the land. This section here, oath. What is an oath of office? There's political oath. There's political oaths. There's politics that come into it. Sovereign, defined in Black's Law Dictionary as a person or body. Then you have to look up what a person is in Black's Law Dictionary. Remedy for every injury. So here we go. Licensing liberty. This is Murdoch v. Pennsylvania. This is the Pennsylvania case. No state shall convert a liberty into a license and charge a fee thereof. No state shall convert a right or liberty into a privilege. The citizen can ignore the license and fee and engage in the right with impunity. Shuttlesworth v. City of Birmingham, Alabama, Supreme Court case. Murdoch v. Pennsylvania. It cites it again, different sections. It goes on and on. Madison versus Mayberry. Or Marbury versus Madison, U.S. Supreme Court case. This is the benchmark case. Every bar attorney out there, every judge out there is taught this particular case. It is your go-to case. Every right, when withheld, must have a remedy. Every injury, there is a proper redress. And you cite that, Marbury versus Madison. That should be at the very heading of every petition that you get autographs for. Marbury versus Madison, quote, every right, when withheld, must have a remedy, and every injury must have its proper redress. That should be at the top of every petition. And it's never on any petition I've ever read. It merely says, we want you to stop doing this, and here's our signature. And then you signature it, surrender God's law, and you have no standing. There's no citation. There's no declaration of status. There's no declaration of standing. There's no citations whatsoever on there. There's no settled matters of fact before any court. And you go in there and you give it to a public employee, and they look at it, and what is the first thing they do? They give it to a bar attorney to review it. The bar attorney looks at it and laughs and throws it in the round file. Because you don't even know how to properly tell your public servant that they're trespassing and violating your rights. Real quick question. No, is it on point? It's got to be on the subject. Go ahead. No, they were not. They had signatures on them from citizens. They don't have standing. The Supreme Court that disavowed or not disavowed, but dismissed all those cases against election fraud. It was the corporation state. It was the state of Texas that brought the lawsuit, not the Texas Republic. And it was brought before an administrative court between two corporations. It was not brought by we the people of the Texas Republic, citing Marbury versus Madison for a redress of grievances. What? Who knows? I know the Supreme Court intentionally dismissed it and told the people, the government actors pretending to be our de jure Texas government, and told them that they didn't have standing because they went into the courtroom as a corporation called the state of Texas. This is basic elementary 1+1 law. And these bar attorneys do not know. So Marbury versus Madison. This is, again, Marbury versus Madison. The government of the United States has been emphatically termed a government of laws and not of men. It will certainly cease to deserve this high appellation if the law furnishes no remedy for the violation of a vested legal right. Here's another one. That statutes which would deprive a citizen of their rights of person or property without a regular trial according to the course and usage of common law, not maritime law, not admiralty law, of common law, would not be the law of the land. Hoke v. Henderson. The right to be let alone is the most comprehensive of rights, and the right most valued by civilized men. To protect that right, every unjustifiable intrusion by the government upon the privacy of the individual, by whatever means employed, must be deemed a violation of the Fourth Amendment, Olmstead versus U.S. Congress cannot alter rights. On the other hand, it is clear that Congress cannot be authorization or ratification to give the slightest effect to a state law or constitution which is in conflict with the Constitution of the United States. So what that basically says, that's American jurisprudence. What that basically says is that Congress cannot make laws that override the constitutional laws of a state. That jurisprudence puts Washington, D.C. Congress in the box that was created by we the people. So here's another one. This is a beautiful one. For example, in United States versus Johnson in 1947, the federal district court, Judge James Alger ruled this, and he stated this in his opinion: the privilege against self-incrimination is neither accorded to the passive resistant nor to the person who is ignorant of his rights. You hear what I'm saying? The privilege against self-incrimination, the Fifth Amendment, is neither accorded to the passive resistant, meaning I'm just not going to do what you tell me, and I'm going to sit here and be quiet. I'm going to ignore you. You can't do that. The passive resistant, nor to the person who is ignorant of their rights, nor to anyone who is indifferent thereof. So, am I controversial? Yes. And this judge tells me to be controversial. Okay? And here he says on. He says, nor, and he says, who is passive resistant, nor to the person who is ignorant of their rights, nor to the indifference thereof. The judge continues. He says, it is a fighting clause. It is a fighting cause. Its benefits can be retained only by sustained combat. It cannot be claimed, meaning your Fifth Amendment right and any of your rights, cannot be claimed by an attorney, an actor to a turn, or solicitor, a next friend counsel. It is valid only when insisted upon by a belligerent claimant in person. McAllister v. Hinkle and the Commonwealth versus Shaw, they also cited that in their decisions. You see what I'm saying? It goes on and on and on. These are all Supreme Court cases here that talk about if you don't stand up and claim your rights, they cease to exist. A right not declared, a right not claimed, a right not acted upon ceases to exist. The courts tell you that they will ignore you if you don't know your rights and you don't know how to stand on them. The courts tell you. So I can go on about this with drivers. Here we go. Thompson v. Smith. Also, Supra, that's the Supra case, and Tech Lines versus Danforth, Mississippi. Supreme Court case. The right of the citizen to drive on a public street with freedom from police interference is a fundamental constitutional right. And it goes on. Citizens have a right to drive upon public streets in the District of Columbia or any city, absent a constitutionally sound reason for limiting their access. And it goes on. Kanesh Mills versus D.C. The use of the automobile is a necessary adjunct to the earning of a livelihood in modern life and requires us, the interest and the realm, to conclude that the right to use an automobile on the public highways partakes of the nature of a liberty within the meaning of the constitutional guarantees. The judge told you that an automobile is your property and you have the right to use it on the public roadways. He did not say motor vehicle. This is why people get arrested, because they don't own their automobile. They think they do. Okay? So how do you go into a courtroom? Whenever you go into a courtroom, you have to do a notice of special appearance. And that notice of special appearance can be as short as 1 page or 4 pages. And that has to be filed before you walk into a courtroom. And it has to be on the public docket before you walk into the courtroom, so it's a matter of record. So how one walks into a courtroom without having the judge throw him in jail for fraud is you walk into a courtroom and it's publicly filed and recorded already, and you sit in the very back of the courtroom. And when the judge calls your name, and I did this in a federal court, and the judge calls your name, and you walk up there and you say, before you cross that gate, remember, once you cross that gate is the railing on a ship. It's symbolic of that. Once you cross that without opening your mouth, you are now in the jurisdiction of the water. You're in an administrative Roman rules bar court. So don't cross that gate. Walk up to that gate and stop. And you say, I am here by special appearance. I am a people, a man. Period. And then you say, as evinced by my notice of special appearance. Now the next question is, we need to properly identify all those parties in the courtroom. Is your honor seeking to be the executor and the trustee of my estate, my minor estate, my Cestacue trust account? And the judge is going to look at you like you're nuts, because you're not supposed to know about that. So then you ask the judge, after he ignores you, because he's going to get a dumb look on his face and he's going to say, uh-oh. And you say, so we may properly identify all the parties here as I've expressed in my public document as a matter of record on this court. I need to see that the judge has all his proper paperwork executed to have jurisdiction in this courtroom over this matter. You must have subject matter jurisdiction, and it must be presented. And I ask the court at this time to present your honor's superior oath of office and your public surety bond documents so that we can determine if you even have jurisdiction over me or dominion over me. And when the judge brings that out, most of them don't, if the judge brings that out, then you've just turned it into a constitutional court. Or the judge can simply ignore you. And if he ignores you, you turn around and leave the courtroom. you just won the court case. Okay? Because the judge did not identify himself. He did not present his public documents. Most often, the judge will get up and just leave. So in this particular case, the judge ignored me and got a big old look on his face. Mr. Lawrence, I've not admitted you into this courtroom. You have to sit down. Okay, he did not answer my questions. Now, the young lady that I was there as a next friend counsel, it was her job to do the same thing. And she didn't. She filed her notice of special appearance. She said the right words, but she didn't hold the judge accountable. The judge admitted that she was compos mentis, meaning she was capable mentally to defend herself as a sui juris. They kept saying pro se. She had to keep correcting the record. And the judge used his chicanery and his fear and his intimidation to trick her into agreeing to something called pretrial conditional release. And all she had to do was utter the word, okay, yes. And she did not need to put a signature on a piece of paper for the judge to hold her binding to a contract. The contract was called conditional release. She wouldn't return a phone call to pretrial services. So the judge brought her back into court, and she didn't stand her ground. She didn't produce her standing. She said she was in a court of equity and that she was the executor of her estate. And the judge looked at her and he says, okay. And he says, tell me what you know about the law. Now, before this, she had been trying to interrupt the judge. She'd been belligerent beyond belief, speaking out of turn and not answering the judge's questions. She was in dishonor, and she failed to turn it into a constitutional court. She was in a bar court. So the judge gave her a chance to turn it into a constitutional court. He leaned up on his chair, and he leaned over the bench, and he says, okay. He says, tell me what you know about the law. And he went like this. And he was quiet. And she said 3 sentences and clammed up. And then the judge was like, and she went, and the judge says, okay, I guess you don't know what the law is. So now the judge can go back to an administrative bar court, and the judge can start his process of administering her minor estate in an administrative law court. And he locked her up for failure to perform on the pretrial conditional release because she wouldn't return a phone call to pretrial services. And he's had her in jail for 2 months, going on 3 months, with no expected trial date in sight. This is what the judge did, and she allowed it. Now, it was the first time she had ever been in any court, and here she is in front of a federal district court judge in Washington, D.C. There's only 2 more courts to get to this. There are only 2 more levels to get to the Supreme Court. So she was a little intimidated, and God bless her for standing up. I love her. She's still fighting. She's still struggling to learn. I did everything I could to teach her. I gave her scripts, and she failed to be response-able. She was not able to respond because she didn't have control of her emotions. So the judge used something called syllogism after he arrested her and had her submitted under one of their rules of syllogism, and he had her submitted for psychiatric review. And they tell you that they're going to do this. Take your phone right now and go to DuckDuckGo and search for the 12 presumptions of the court. I'm going to go over that in a minute. The 12 presumptions of the court. Now, I had that in my paperwork, but it has since escaped. I passed it around for folks to read it at the last event, and I don't think it was given back to me. I'll have to print out another copy of it. That's why I'm having you look it up. The 12 presumptions of the court, syllogism, and it did not make it back to my possession, so I can't share it with you or read it. The 12 presumptions of the court. Did anybody find it? You did find it? Okay. What are the 12 presumptions of the court? Syllogism. You're going to be hard-pressed to find that if you use Google. So what are the 12 presumptions of the court? The first one is what? Presumption of public record. And that means that the judge is going to assume and presume that you think this bar court is a public record court, when actually it's not, unless you claim it. Isn't that what it says? Keep reading. They're going to assume and presume that you know it is not a court of record. Here you go. Come on up. For the people on there. Okay, so did y'all read that? Or did you hear what she said? They're making assumptions about being a constitutional court or a private bar guild court. Every judge knows this. Every attorney that you've ever hired knows this. And they never tell you. It's their dirty little secret. So if you're an attorney or you've hired one for any type of a criminal case or a traffic court case, and they didn't tell you about the 12 presumptions of the court, they lied to you. It is a lie by omission, and you should be very upset with them. I don't care if you've known them for 30 years, they won't tell you this. Is it controversial? Would I expose it? Because they took an oath to the bar guild that ended with these words: the courts, comma, our client. An attorney, the definition of an attorney, if you go back long ago, before this, way back in England, an attorney is an actor to attorn, to re-present. They are a privateer. The definition of a privateer is a pirate. Attorn, an actor to attorn, to turn over what belongs to someone else to another. You give them power of attorney when you hire them. There's a way you hire an attorney. You retain all your rights, every single one of them. UCC 1-308. Without prejudice, retaining all my rights. The attorney is hereby engaged to do specific things and no more. And under your autograph, you put UCC 1-308. That binds that lawyer's hands, that attorney's hands. A lawyer did not take an oath to the Bar Association. There are two of everything. A lawyer is a law sayer. Law sayer became lawyer. An attorney has always been an actor to attorn. So what is syllogism number 2? You're going to love this, folks. Wait till they get the one where they consider you an idiot. Go ahead.
Number 2, the presumption of public service is that all the members of the private bar guild who have all sworn a solemn, secret, absolute vote to their guild then act as public agents of the government, or public officials making additional oaths of public office that openly and deliberately contradict their private superior, oaths of their own guild. Unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under public oath. Awful.
Trustees under public oath. They are not under their oath to uphold and defend the Constitution. I'm going to say it again. They are not under their constitutional oath of office to defend the Constitution. These are judges. And when they go around this country and they ask you for their vote, start asking them what their superior oath is and if they disavow the 12 presumptions of the Bar Guild. And they'll run from you as fast as they can. I was doing a speaking engagement up in Bucks County, Pennsylvania. 650 patriots in the room. It was a big room. Okay? Was anybody up there when I gave? I saw the video of it. You watched the video of it. And in the back, guess what was in the back? About 5 judges running for office. When I started talking about something like, I said, look at them run. Some of them literally dropped their campaign signs, their yards, and ran without breaking into a full run out of the venue. They didn't want anybody asking them about presumptions of the court or anything I was talking about. Yeah. Pardon me? They are officers of the court. She just read you the presumption. They are officers of the court. They take a bar guild. The courts, their clients, is how their oath to the bar guild ends. The courts, comma, their clients. Not the courts and or their clients. The courts, comma, our clients. Well, sure they are. Even your defense attorney, if it's a criminal case in a district court, even some of them get cuts of the bill that was paid by your Cesta QV trust account. No. The fines are different. The fines come out of your pocket in fiat currency. Yeah, in addition. Yeah, in addition. Yep. The fees you're paying are court costs. The profit of the court comes from your Cesta Q trust account. Cesta Q trust account. CESTIQUE. Cesta Q is a dead vessel. The Cesta QV Act of 1666 was passed in 1666. Isn't that an interesting date? And it defined a corporation. It defined what a dead vessel was. It defined a person, a personification. It defined what life is. You're a dead vessel, a monster. You're an enemy of the state. Cesta Q trust account is there and created to fund government. They don't tell you about it because they don't want you to know. You can express the trust. When you do, the U.S. Treasury Department calls it rapture. You've achieved rapture. You are now sovereign. You are as free as you could possibly be. Now, part of getting there is that you need to establish your estate, because paupers cannot be sovereign. You don't own anything. You own certificates of things that you bought with fiat currencies. You have to restore those allodial titles to all your property. You have to claim all your household items. All of them, even your lawnmower. Everything that's attached to your home. Your kitchen utensils, your knives, forks, all household items. You claim them on your property list and you record it on the land. That you now own them. You have superior title ownership of them, and you generate your own title called your declaration of ownership or your declaration of property, your declaration of private property, your declaration of real property. This is the process. So go ahead. We got a little off track there, but I want to stick with presumptions and assumptions.
Number three, presumption of public oath is that all members of the private bar guild acting in capacity of public officials who have sworn a solemn public oath remain bound by that oath and therefore bound to serve honestly, impartially, and fairly as dictated by their oath. Unless openly challenged and demanded, the presumption stands that the private bar guild members have functioned under the public oath in contradiction to their guild oath.
So did you hear what she said? That's enough of that one.
Okay.
Did you hear what she said? What that reads? That unless you declare it a constitutional court and you rebut and repudiate their assumption number 3, that it's not a constitutional court. It's a private bar guild matter, and you're under Roman rules. That's what that means. That's number 3.
So we should go in and just say no to all 12?
You have to rebut them continuously. They will constantly see how awake you are if you are response-able. If you are not response-able, able to respond, if you are not response-able, they will assume and presume at will. And they will try a minimum of 3 times to usurp each and every one of these 12 presumptions and your rights as a man, as a woman, as a people. No. What does it mean for all your rights to stay intact? What are your rights? What are your rights? What does that mean? Are you a party to the Constitution? What's your status? What's your standing? What are you demanding it for? You see, the attorney, an attorney is a bar guild member. Their superior oath is to the bar association, the courts, their client. That's their superior oath unless you rebut it. Go ahead, number 4.
Number 4, the presumption of immunity is that key members of the private bar guild in the capacity of public officials acting as judges, prosecutors, and magistrates who have sworn a solemn public oath in good faith are immune from personal claims of injury and liability. Unless openly challenged and their oath demanded, the presumption stands that the members of the private bar guild, as public trustees acting as judges, prosecutors, and magistrates, are immune from any personal accountability for their actions.
So you see that? They assume that you know that they are immune from their actions. And unless you rebut it, it stands as a fact, a settled fact before their court. So isn't that amazing? So I guess give you here is United States U.S. Code, Title 18, Section 241 and 242. Title 42, U.S. Code, Section 1983, 1985, and 1986. If you look those up, especially Title 42, says that judges are personally liable when they trespass upon your rights. And you can hold them accountable for treason. This is what the Title 42, what I just said, says that Okay, and I'm looking for the exact, wouldn't you know it? I can't find it when I want to find it. There's too much paper up here. But anyhow, let me see. I'm gonna look till I find it because this is very, very, very important. So, under the U.S. Code, what I just read off, Title 18, write this down, and you can look it up later, because I can't find the exact language. I don't know what happened to it. Title 18, U.S. Code, Section 241 and Section 242 deals with conspiracy to deprive you of your rights. Okay? If upon conviction, the judge is subject to a $10,000 fine or 10 years in jail or both. And if theft results, if they take your property, life in prison. Under Title 42, U.S. Code 42, clearly establishes the right to sue anyone who violates your constitutional right. The Constitution guarantees he who would unlawfully jeopardize your property loses their property to you, and that's what justice is all about. Okay, so look those up. Title 42 in the U.S. Code, and you want to look for 1983, 1985, and 1986. And it really bothers me that I can't find those U.S. codes because they are really, really super important, and I thought I had them listed on this document. Aha! Here we go. Found them. I went back too far. Okay, so Title 18, 241, Conspiracy Against Rights. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in a state, in the free exercise or enjoyment of any right, they shall be fined under this title or imprisoned not more than 10 years or both. Deprivation of rights under the color of law. This is important. Remember, everything is corporations. All these courts are incorporated. The Bar Guild is a corporation. The judge working as an administrative bar judge in a Roman rules court is not the law. They are an administrative bar court. Deprivation of rights under the color of law. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state to deprivation of any rights shall be fined under this title or imprisoned not more than 1 year or both. Then you look at Title 240 or USC 42, 1983, civil action for deprivation of rights. You can sue the judge, a police officer. You can sue them if you're a person. If you're a citizen, you can sue them. If you're a people, you send a bill to their public bond surety company, and their insurance company pays you for them violating your rights if you're a people. If you're a citizen or a person, you have to go into a court and ask permission. Okay? USC 42, 1985, conspiracy to interfere with civil rights. If two or more persons of any state or territory conspire for the purpose of depriving either directly or indirectly any person of their rights, the party so injured or deprived may have an action for the recovery of damages against any one or more of the conspirators. You can hold them personally accountable. You can send them a bill if you're a people, and their public insurance company, their public bond, their public surety bond insurance company will have to pay the bill. Okay? Actions for neglect to prevent. This is what you can get the sheriff for not upholding the Constitution. There's deputy sheriffs and there's bailiffs. The bailiffs and the sheriffs are not, especially the sheriff in a state or county court. The sheriff is not there to uphold what the judge says and arrest you. The sheriff is there to first defend your constitutional rights from the judge and his actions. The sheriff is there to put the judge in his place. The bar attorney has educated the sheriff to think that they are there at the will of the court, the judge. It's not the case. That's not the case. And these sheriff handbooks that I told you about, over 130 some pages, schools the county sheriffs on why they're in that courtroom through real law, through Supreme Court cases, citations, and standing. And most of the sheriffs do not know these things. They are hidden from them by the bar attorneys, known as their county prosecutor. Okay? Why do we have an attorney general for the United States when it's not in the Constitution to have an attorney general? Because it's a corporation. And a corporation needs an attorney to administer the bar rules under the law of the water. In Pennsylvania, we elect our attorney general. State attorney general, yeah. It's crazy. So, go on. I'm keeping you up here. You want to sit down?
No, I'm fine.
Okay.
Number 5, the presumption of summons is that by custom of summons, unrebutted stands, and therefore one who attends court is presumed to accept a position, defendant, juror, witness, and jurisdiction of the court. Attendance to court is usually invitation by summons. Unless the summons is rejected and returned with a copy of the rejection filed prior to choosing to visit or attend, jurisdiction and position as the accused and the existence of guilt stands.
Did you hear what she just said? This is powerful. This is they assume. Read that again if you would, please, ma'am.
The presumption of summons
The presumption of summons.
is that by custom a summons unrebutted,
Hold on. By custom.
a summons
Now, you see what I just read to you? Under the U.S. Code, a custom cannot take away your constitutional right under Marbury versus Madison. Go ahead.
unrebutted stands, and therefore one who attends court is presumed to accept the position, defendant, juror, witness, and jurisdiction of the court. Attendance to court is usually invitation by summons. Unless the summons is rejected and returned with a copy of the rejection filed prior to choosing to visit or attend, jurisdiction and position as the accused and the existence of guilt stands.
Did you hear what that says? That a summons is an invitation. Lawfully, a summons is an invitation. Legally, a summons is a presentment, an offer to contract. And when you don't rebut it and you walk across the courtroom threshold and you open the gate and enter the ship, you accept the role of the defendant, the jury, or what was the other one? I can't remember. The witness. You
Defendant, juror, and witness.
defendant, juror, witness. You accept that role. When you cross that gate, you accept it. And the court presumes that you know that you have the right not to contract with them under water, under commerce. You have the right to refuse any presentment. You have 72 hours right of refusal. Under UCC 3, Section 201, 202, and 203. Rescission for fraud and swindle. And you return that summons. Your offer to contract is hereby rescissioned, properly spelled. I do not wish to engage in any contract with this court. Unless there is a victim, if it's a code, statute, or ordinance violation, unless there's a victim, it's a simple contract. You have to consent. And I can read you more Supreme Court cases up here that talks completely about consent. That no court has jurisdiction over you or police officer over you unless you consent. And you consent by giving them your driver's license. You just agreed that you're a party to a contract called the Motor Vehicle Code. Is what I'm teaching you controversial? Yes. I'm teaching you real law. I'm teaching you what your status and standing is. And what the what the stuff made up is that they use against you to deprive you of your God-given rights. Yes. Real quick, man, real quick. Real quick, man, come on. So you didn't even have to go, and they told you. Yeah, fantastic. Okay, next one.
Number 6, the presumption of custody is that by custom of summons or warrant for arrest, unrebutted stands, and therefore one who attends court is presumed to be a thing and therefore liable to be detained in custody by custodians. This includes the dead legal fiction non-human person that corporate government's rules and regulations are written for. Custodians may only lawfully hold custody of property and things, not flesh and blood, soul-possessing beings, unless this presumption is openly challenged by rejection of summons and or a court. The presumption stands, you are a thing and property, and therefore lawfully able to keep in custody by custodians, to be kept in custody by custodians.
Did you hear that? I want to scream. I want to scream. I want to scream. This is written by judges and attorneys. You are a thing. You're not even alive. You're a thing. You're a person. You're dead. Yes. This is written by attorneys. It's part of their oath to the Bar Guild. Does this piss anybody off? Yes, it's what they're doing to the January 6th people. The ones that destroyed that building, lock them up, hold them accountable. The ones that walked in there, like the 80-year-old grandmother that walked in there and says, oh, this is nice, and then walked back out and they arrested her. What is wrong with the people that went and arrested that woman? What is wrong with some of these FBI agents? What's wrong with them? They're evil. There's no other excuse for it. They don't know about the presumptions of the court. All the judges that are holding those people in court know all this stuff. Your attorneys that you hire to represent you know all this stuff. They took an oath to uphold this shit. And I'm sorry for using the word shit, but my dander gets up. We're in a battle for our liberty and our freedom. We're in a battle between good and evil. And if I use the wrong word every once in a while, God help me. I'm passionate about what I'm doing. Amen. We are going to restore God's law back to this nation. And if I use the word shit offends you, so what? Be offended. I am a soldier. And I will walk with the armor of God. And this stuff drives me like you wouldn't believe. Can you feel me? Yeah, we can go on and on about that. Give me the next one, hon. You got my blood up.
Number 7, the presumption of court of guardians is the presumption that as you may be listed as a resident of a ward of a local government area and have listed on your passport the letter P, you are a pauper and therefore under the guardian powers of the government and its agents as a court of guardians. Unless this presumption is openly challenged to demonstrate you are both a general guardian and a general executor of general executor of the matter, trust before the court, the presumption stands, and you are by default a pauper and a lunatic, and therefore must obey the rules of the clerk of guardians. Phew.
Did you hear that? Read that puppy again, because it's really important. I want you to listen to these words. Every word means something. Go ahead.
The presumption of the Court of Guardians is the presumption that as you may be listed as a resident of a ward of a local government area and have listed on your passport the letter P, you are a pauper and therefore under the guardian powers of the government and its agents as a court of guardians. Unless this presumption is openly challenged to demonstrate you are both a general guardian and a general executor of the matter trust before the court, the presumption stands that you are by default a pauper and a lunatic, and therefore must obey the rules of the clerk of guardians.
Did you hear that? Yeah. They're updated. They update them. This particular publication, I don't know, because I'm not a bar member. I'm not privy to that information. Okay? When it was published or when it was written or what. Now, we didn't really have a bar treaty with the treaty with the Bar Association until the middle 40s. The middle 40s is when we started really having agreements with the Bar Association through the UN, United Nations. Remember, in 35, Franklin Delano Roosevelt started the New Deal. I mean, I could go into, yeah, bless you. I could go into how and why the Great Depression, roaring 20s, and then we had the Great Depression, the fall of the stock market. That was all manipulated. The Second World War, the way it came to an end, was all manipulated. We gave up our sovereign borders after World War II. We gave up 50 miles of our southern border to the United Nations and the city of New York, Manhattan Island.
Get off the gallows.
You see what I'm saying? So yes, your passport does have a P on it. Mine has a P on it. Is that your state national passport?
No, I have ours.
Yeah, they should have a P on it.
Mine has a P on it.
Yeah, you're a pauper. Yep. You see how you overcome that status of a pauper? Is by doing this and wave that in the judge's face. I am not a pauper. And you walk into that courtroom and you drop your gold and silver on the table in front of. Doesn't that sound beautiful? Okay. And if you have 5 or 6 of them, I have a whole brown bag of them. Clink, 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 clink. Good, good, good. I only carry 2 with me because they're heavy. You know, an ounce of gold is heavy. I mean, it's for as little as it is, as heavy as it is, you know. So anyhow, then does it? I'm serious, folks. Does this drive you insane? How many of you ever hired an attorney for any reason whatsoever? Yeah. Does this drive you up the wall? Go ahead. Oh, it gets better. It gets better. Wait, keep going.
Number 8, the presumption of the Court of Trustees is that members of the private bar guild presume you accept the office of trustee as a public servant and government employee just by attending a Roman court, as such courts are always for public trustees by the rules of the guild and the Roman system. Unless this presumption is openly challenged to state you are merely visiting by invitation to clear up the matter and you are not a government employee or public trustee in this instance, the presumption stands and assumed as one of the most significant reasons to claim jurisdiction simply because you appeared and
it goes on, simply because you appeared. And then it goes on to the next one, the next presumption. So read that again, because there's a really, the sticky point of that I want you to hear again.
The presumption of Court of Trustees is that members of the private bar guild.
Pause. The presumption of Court of Trustees. They are acting as a trustee of your minor cesta Q trust account, which is worth millions of dollars, They are acting as trustee to get you to consent so they can send a bill and they can put that money in their coffer accounts that you don't know about, and they can split it up and make money off of us. It's fraud. The Cestacue Trust Accounts was created to fund government, not the court system, not the Bar Guild. Go ahead, continue.
As such, courts are always for public trustees by the rules of the guild and the Roman system. Unless this presumption is openly challenged to state you are merely visiting by invitation to clear up the matter and you are not a government employee or public trustee in this instance.
Pause. A government employee. You have to throw off that you're not a government employee. Citizen, municipal servant, a government employee is synonymous. Citizen. The court is acting as your Zen master. You is a citizen. You are not a citizen. You are a people, a state national. They assume you are a municipal employee. Go ahead.
Not a government employee or a public trustee in this instance. The presumption stands and is assumed as one of the most significant reasons to claim jurisdiction, simply because you appeared.
Simply because you appear. I mean, this just, that was number 9? 10, 11, 12. We only got 3
8.
more. Oh, that was 8?
Yeah.
9, 10, 11, 12. We got 4 more. Keep going.
Okay. Number 9, the presumption of government acting in 2 roles as executor and beneficiary is that for the matter at hand, the private bar guild appoint the judge magistrate in the capacity of executor, while the prosecutor acts in the capacity of beneficiary of the trust for the current matter. Unless this presumption is openly challenged to demonstrate you are both a general guardian and general executor of the matter trust before the court, the presumption stands and you are by default the trustee, therefore must obey the rules of the executor, judge, magistrate.
They're talking about your Cestacue trust account. This is all about getting to your Cestacue birth trust account that has millions of dollars in it. And it's fraud. And you think you're in a court of law, when really you're in a court of thieves and pirates. Keep going, hon.
Okay, number 10. The presumption of the executor dison tort
Executor dison tort
is the presumption that if the accused does seek to assert their right as executor and beneficiary over their body, mind, and soul, they are acting as an executor dison tort or a false executor. I don't know why I'm having trouble.
No, that's okay.
Challenging the rightful judge as executor. Therefore, the judge magistrate assumes the role of true executor and has the right to have you arrested, detained, fined, or forced into a psychiatric evaluation. Unless this presumption is openly challenged by not only asserting one's position as executor, as well as questioning if the judge or magistrate is seeking to act as executor dison tort, the presumption stands and a judge or magistrate of the private bar guild may seek to assistance of bailiffs or sheriffs to assert their false claim.
To assert their false claim. The bar guild is telling you that they make false claims and they use the sheriff and the bailiff to enforce them. Are you guys as mad as I am? I mean, I didn't make this document up. You all searched it on your phone. Half of you found it on your phone. I didn't make it up. This is their stuff. Go ahead, hon. Number
11. The presumption of incompetence is the presumption that you are at least ignorant of the law, therefore incompetent to present yourself and argue properly. Therefore, the judge magistrate as an executor has the right to have you arrested, detained, fined, or forced into a psychiatric evaluation. Unless this presumption is openly challenged to the fact
Yep.
that you know your position as executor and beneficiary and actively rebuke and object to any contrary presumptions, then it stands by the time of pleading that you are incompetent. Then the judge or magistrate can do what they need to do to keep you obedient.
An incapacitated, incompetent legal idiot. They make the assumption, the presumption that you're an incapacitated legal idiot and you're crazy.
So I guess we know now who Q is, right? The says the Q account of we the people. And that's what you just said.
The Cesta Q Trust account,
Q, we the people.
we the people. Go ahead.
Number 12.
Number 12. Then we're
Number
gonna take a
12.
break.
The presumption of guilt is the presumption that as it is presumed to be a private business.
Slow. Oh, pause. The presumption of guilt. Aren't we supposed to be presumed innocent until proven guilty?
So we thought.
So go ahead. What's the corporation? You're presumed guilty. Go ahead.
Is the presumption that as it is presumed to be a private business meeting of the Bar Guild, you are guilty whether you plead guilty, do not plead, or plead not guilty. Therefore, unless you either have previously prepared an affidavit of truth and motion to dismiss with extreme prejudice onto the public record or call a demurrer, then the presumption is you are guilty, and the private bar guild can hold you until a bond is prepared to guarantee the amount the guild wants to profit from you.
So you see, you never go into a courtroom and plead not guilty. Never. You proclaim your innocence. There's a huge difference. You plead as a citizen. You proclaim as a people. We're going to take a break. Is anybody pissed off as I am about this stuff? Let's take a 5 or 10 minute break. I need to go outside. I can get to my den. Thank you so much, hon. You did a wonderful job. Let's give her a round of applause, folks. Thank you so much. God bless you. Does that piss you off or what?
Well, you know, it started with Genesis 11, the Tower of Babel.
Yes.
Then they came down to confound the language of men, and
And they did.
they did, and they haven't stopped.
The Tower of Babel. That's exactly right. This young lady says about the Tower of Babel in Genesis 11, 1 through 19. The Tower of Babel. They come down from the Tower of Babel to confuse our language so we can't communicate with one another. Everybody listen up. Genesis 11. They come down from the Tower of Babel to confuse our language so we can't communicate with one another.
God did that to the people.
No.
It says the Lord. It doesn't say God, and then it says, then they came down.
Then they came down. You have to go back. Which version of the Bible are you? Remember, everything after 1611 is all stuff made up. It's changed. I have two Bibles. I have a 1611 and I have a 1976 Bible. And when I read through it, it's like night and day. They completely change words. They delete words. They delete entire paragraphs in the new Bible. If you want to know what the truth is in the Bible, get yourself a brand new printing of the Geneva Bible as it was written. That is the true Word of God. King James Version, no, I mean seriously, the King James Version is a version from the King of England. The 1611 is fairly decent, but it's not the Geneva Bible. So if you look up, like I got into a discussion on the channel about the word person or people, and the newer version, and some people came back and said, well, I found it this many times in the Bible. I did it, downloaded it digitally and searched for the word, and it's 11,000 times they use the word this person. Well, then someone downloaded the Geneva Bible, and they said, people got changed to person by King James. The original Bible was people. So just that one word makes a huge difference in the interpretation of the Bible. You know? Yes. So it changes It changes so many different things. Thank you so much,
Could
hon.
I have one more thing?
Yeah.
As the U.S. military and other global militaries went through the tunnels between Jerusalem and the Vatican, they found 777 books of the Bible. Humanity has been badly played.
Yes.
I ask you all to assume nothing but do your own research, because the Bible was played with, the Bible we have today. I don't
Yes.
care whether it's King James or the Amplified Bible. They've all been screwed around with
That's
to
exactly right.
confuse us. And that's why
Yes.
Christianity gets so fragmented, because
Yes.
not everybody has the proper instruction with the proper medicine, with the proper
Yes.
message.
She's exactly right. David tells a story, when he expressed his trust and when he was going through the process of learning all this. David took 30 years to learn what he learned. Okay, so one of the things that David said that he tells a story about is when he went to the Vatican as his status, he has a pretty unique status around the world, he was able to gain access to the archives in the Vatican. And he spent a couple of weeks over there reading and taking notes. And he said the Bible, when it's stacked up, is about this tall. He said, and we get to see this much of it. Where is the book of Enoch in the King James Version? It's not in there.
And the book of Maccabees.
Yes, and the other books, and the other books, and the other books, and the other books. Folks, we have been lied to for centuries. Centuries upon centuries. Anyhow, let's take a break.
What's David's last name?
What's that?
David's last
David Straight. Yes. He's a direct descendant from one of the original signers of our Constitution.